Okay. Welcome everybody. For those of you who don't know me, my name is Dina Lupin. Um, I am an associate professor at the University of Southampton, um, and a lawyer from South Africa. And I wanted to welcome you all to this webinar, and just I know that some of you have attended a few of our webinars. What we're kind of really trying to do between now and the deadline for submissions, which currently for observations and for those who've already been accepted as amici stands at the end of March. So I thought I would just start with a little welcome and a few comments about the request for an advisory opinion before we hand over to Z, who is kind of the lawyer who's really been the driving force behind the drafting of the application of the request, and has been sort of our African court sage, guiding us all on this process of engaging with the African court. We will make this recording available, so if you know of anyone who wasn't able to be here today, but wants to have some better understanding of how to submit a request to be admitted as an amicus, or to submit a brief as an amicus, or as an observer, and Z will talk about the distinction between an amicus and observer in a moment, then please just share this with them. I know this isn't an easy time for everybody, so we're just trying to create a kind of wealth of resources that people can draw on as they engage with the court. So I thought I would just start with a very kind of broad introduction and say a couple of things about the request for an advisory opinion, but also about some of the resources that you might find useful as you work on your own submissions, or as you kind of engage with the court. So I'm just going to share my screen. So first of all, for those who don't know, you can find a copy of the request for the advisory opinion on the African Climate Platform's website. So if you are struggling to find it, you want to have a look at it, it's there on their website. So as most of you know, in 2025, the Pan-African Lawyers Union, on instructions from a group of African civil society organizations, sort of being coordinated by the African Climate Platform, submitted a request to the African Court on Human and People's Rights for an advisory opinion on the obligations of states with respect to climate change in relation to the African Charter on Human and People's Rights. And if you haven't yet had a chance to have a look at the request, I would recommend having a look at it when you have a chance. It sets out a quite kind of clear, compelling background on the different kinds of rights-based impacts that climate change is having, both from a regional perspective, so thinking about different parts of the continent, as well as from a kind of cross-cutting rights and vulnerabilities perspective. And as you can see in the table of contents there, a particular focus on women and girls, children, the elderly, indigenous peoples, and human rights defenders. it sets out the kind of legal framework for requesting an advisory opinion of this kind, which might be useful for those of you who are engaging with the court and the court's particular structure for advisory opinions for the first time. And then also discusses some of the key rights that are being called on for consideration. What I wanted to just have a look at was the particular questions that have been, sorry that you're watching the scrolling, I hope it's not making you feel seasick, the particular questions that have been put before the court. And the reason why I just wanted to draw our attention to these questions is because as amici or observers, one of the things that the court is looking for, particularly from those who are wanting to act as a friend of the court, to submit an amicus brief, is support or assistance, particularly in addressing the questions that have been put to the court, but at the same time, sorry, I'm talking and scrolling at the same time, which is as multitasked as I can manage. So apologies that you're watching the scroll so slowly. I should have checked the page number first. At the same time, this is not a limited set of issues that one can address in an amicus brief, and I think T will talk about that a little bit more. But it is very useful, I think, to be able to connect as far as possible and as far as relevant. Have I rolled right past it? See, do you know what page I'm meant to be on here? As far as relevant, to connect to the questions that have been put before the court in the request for an advisory opinion. Sorry, everyone. Give me a second while I find the page that I'm looking for. And if someone wants to tell me what page it's on, that would be very kind. All right, I'm not going to waste your time with scrolling back and forth through this document. Instead, I'm going to take you to another document that you may find useful, which we have drafted as a team. Which, sorry, Z.
Page 35, sorry.
Say that one more time.
Page 35.
Page 35. Thank you.
Questions, right?
Yes, that's exactly what I was looking for. Page 35. Thank you, Z. Sorry. So, is it 35?
Yeah, somewhere.
Yes, there. Sorry. Yes, thank you very much. So, as I was saying, that the requesters have articulated a series of questions for the court to particularly engage with and answer. And I wanted to draw your attention to them, obviously not knowing what page I was looking at myself, because I think this might be useful both for thinking through your own amicus briefs, but I think this also sums up in quite a useful way some of the key concerns that the requesters identified in their request. And so those are at paragraph 94. So please have a look at that if you haven't had a look at it before, and particularly some of the articulation around questions about what the applicable human rights obligations are, and the kind of substantial responsibilities that we would like to see the court identify in relation to the human rights obligations of African states in conditions of climate change. And then, as I was saying, connected to that, we've drafted something called the Hopes and Ambitions document, in which we set out, which is really just meant to be helpful, not a guide or a sort of mandatory reference document, that sets out what some of our sort of hopes and ambitions for what we want to see from the African court. Because there is a question about, since we now have 3 international courts giving advisory opinions in relation to human rights obligations under climate change, including significantly the one from the ICJ. The question is, like, what do we in addition or particularly want to see from the African court? Why is this such a uniquely important request for an advisory opinion? And we've tried to set out some of the reasons why we think this is a uniquely important, critical advisory opinion in our hopes and ambitions document. And so this is just a note to encourage people to have a look at the request and to have a look at this document at the same time. I'm going to hand over to Z now, but just before I do, I just wanted to point out 2 other resources that are online that you might find useful. One is on the African Court's own website. It has a list of its basic documents, including the rules of court and the practice directions. I fully appreciate that these documents might be very kind of alienating or foreign if you haven't engaged with them before, or if you don't come from a legal background. And so I want to emphasize that we're here to kind of support engagement with these texts and to help you navigate them a little bit. But this is, including the charter itself, but at 3 and 4, the rules of the court and the practice directions govern the submissions that you or your organization are going to be making. And it's worth pointing out that the practice directions were updated in 2024. So there is an older version of them that does sometimes come up if you do a Google search, and to just note that those are no longer the current practice directions. So you should be looking at the most recent ones if you do refer to these documents directly. And then the last thing I'm just going to draw everyone's attention to, again, before I hand over to Z, is a document that we as the working group have been putting together, which is a database of those who are submitting amicus briefs and observer briefs. And this is really meant to be a resource for us, so that we can see who else is submitting a brief on the kinds of things we are all submitting a brief on. So you might want to know who else is submitting a brief on Southern Africa, or on children's rights, or on whatever issue it is that you want to engage in. So it's an opportunity to kind of build networks and strengthen collaboration between those of us who are submitting amicus briefs or observer briefs. But also we want to use this database in our sort of public-facing engagements to emphasize both the importance of this request for an advisory opinion and the breadth of the issues that climate change brings to the fore in an African context. And so this is both a resource for networking and strengthening the work that you're all doing, and it is at the same time a little piece of advocacy that we are using to really build visibility and encourage state and regional body engagement with the process. So if you or your organization are not already on that spreadsheet, I will put a link to it in the chat. Please do add your details. We invite you to put your contact details, but obviously feel free to not include them if you don't want to. Just information about your organization and what you are planning to submit on the focus of the brief would be incredibly useful, I think, as a shared resource. Okay, I've talked enough. I'm going to stop talking. I'm going to hand over to Z. And
Thanks so much, Dina, and greetings to everyone. Obviously, we didn't get to do full introductions for everyone, but I see we've got about 47 or so thereabout people, which is quite exciting to have people that have got interest in these processes. I'm assuming we've got lawyers, activists, and all people that have got an interest in some of the work that we are doing around the climate justice case, or just generally the advisory opinion process before the African court, which is what I'll basically talk to. I'm able to share my screen. Am I able to do that from here? I think I can do that, right?
yes, you should be able to.
Okay,
Otherwise, let me know if I should upload
yes,
it.
let me see. Okay, I think we can be able to do that. I'm not addicted to technology. Sometimes it always lets me down, but you should be seeing my screen now.
Yes, we can see it.
All right, great.
You want to
Thanks.
go into full presentation
Oh, yes,
mode.
let me do that. Yeah, thanks. All right. Is that all right?
Perfect.
All right, thanks. Thanks so much. Okay, so great. So I'll just pick up from where Dina just left and say, because we've got this climate justice case that we've filed, we've thought it very important to talk to partners and colleagues like yourselves on the call to encourage you to participate in the process. So just as a part of building each other's capacity, I'll just briefly talk about the opinion process, how to file an advisory opinion before the court. I assume some or most of you know that, so I will not spend a lot of time doing that. I'll spend more of my time talking about the amicus curiae process, which then follows the filing of an advisory opinion, so that hopefully it can assist some of you colleagues that intend to file, or that have not filed, or that have filed but have got questions around the process as we go forward. And then hopefully we have some time to discuss after my presentation. So hence I called it nuts and bolts. It's just the basic things that everyone needs to pay attention to when engaging with the African court process. So quite obviously, being a legal process, we always start with the sources of law, and you cannot participate in the court proceedings without paying attention to two to four sources of law, right? We know that the court itself is established by the protocol, and the protocol is the one that provides the substantive and procedural guidance in terms of how you work with the court. The protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, quite a wordy title, so I'll just call it the protocol to the court. Then, of course, we've got the rules of procedure that are derived from the protocol itself to govern further and clearly articulate some of the processes. And the court came up with further directives. They've got what they call the practice direction of 2024. That also further explains some of the processes that it embarks on. And of course, we rely on precedents from previous judgments that have come from the court. The court has got contentious jurisdiction and advisory jurisdiction. I won't talk about the contentious ones because we are focusing on advisory opinion proceedings. But for your own information, if you want to know what the court does, the court deals with the contentious jurisdiction, which means cases that are litigated that come before it, and the advisory opinion, which is what we're going to spend our time on. So those 44 documents, I think they are in one of the databases that Dina just shared, but you can, of course, find them on the court website, which Dina also showed you in a presentation. So you can quickly look in any of those documents if you want clarity, because I'll just speak broadly about what they say without going into detail. So those are our four source documents. The important thing to note is that for advisory proceedings, there's a different process compared to the contentious jurisdiction. The advisory proceedings, it's a narrow access to the court, and if you look at Article 4, it shows you who can bring an advisory opinion request before the court, or who can file an advisory opinion request before the court. And we know that there are four entities, if you like, the member states of the AU, are at liberty to do that. The AU itself as an organ can do so. And of course, the many organs of the AU that you know of can request advisory opinions from the court itself. And this one is where we have an interest, which is an African organization recognized by the AU. For most people that work with the AU processes, you know that you can do a lot of advocacy work with the AU. But what the court has interpreted in past judgments is that for you to be able to file a request for an advisory opinion, you must actually have a formal agreement with the AU. And I can tell you there are not too many organizations that have got that, which is why when you go to the website that Dina was showing you and you look at the organizations that have filed successfully, you'll only find one or two, which I'll talk about in a moment. So if you look at our case, the climate justice case, we filed it with PALU, who is our partner in this process, because PALU has filed prior cases and they've been recognized as an organization, as an African organization that is recognized by the AU. Other organizations have tried it and their cases died a stillbirth. So for our purposes, we are working on this case in partnership with PALO, and we hope that we will not have challenges on the procedural side because there is precedence to that end. So I think that is important to note for those that would want to file advisory opinions. I'll be calling them AOs after this process that we've done. You need to be very aware of the procedural limitations in terms of who can bring a case. So assuming that you have been able to go beyond this step, either you're a state, you're AU, or you're an organ of AU, or you are recognized by the AU, then you must file an opinion or a request for an opinion that speaks to the African Charter on Human and People's Rights. Most of you working in the human rights space, you would know that that's the preeminent human rights charter on the continent. So your request must either speak to that, or, and this I think the court is very broad, says it can relate to any other relevant human rights instrument, which means you can bring a question for a request on an advisory opinion on any other, not just African human rights instruments, but your typical global human rights instruments, like as an example, your International Covenant on Civil and Political Rights, your CEDAW, your International Covenant on Social and Economic Rights. There's a question that you think, and I think it has to relate to some African context. Otherwise, there will be no point in bringing it before the African court. If, let's say, for example, it's something that relates to an Indo-American situation, I think strategically you would just go to the Indo-American system. So I would add that on the African Charter and the International Human Rights Instrument, there has to be something that connects it to the context on the continent based on the cases that have come before the court and just my own interpretation of the framing of the law. So two things: who are you? Are you qualified to bring a case? Secondly, does it relate to the African Charter on Human and People's Rights or any other relevant international human rights instrument? Then you are in. So you can then file your case. There is if you go to that website that was shown by Dina African Court on Human and People's Rights website, there is a standard form that you can use, that you must follow in terms of the structure of the AO itself. But I'm not going to spend much time on that because I want our focus to be on the amicus curiae briefs, which is the process that you want. We want people to get on board in this climate justice case that Dina was talking about. Otherwise, feel free to look at that form and structure and always engage with some of us if you want further clarification on that. So let's say a case has now been brought before the African court, an advisory opinion case. There is this second way in which you can join proceedings, which we call amicus briefs. You find that it's an internationally recognized process in most international tribunals like the ICJ, the Inter-American Court, but also even in domestic processes like before constitutional courts, you find this term used a lot, amicus brief. And it's generally for the same reason. This is a third party that joins a matter that is already before the court, in this case, the African court. and you have an interest in that particular case, and you've got some expertise in that particular case, or you've got an angle that you want to bring before the court that helps the court to make a determination on the issues that are already before it. So broadly speaking, if you can demonstrate that, you can file an amicus brief. And we always encourage human rights organizations to do that, because it then enriches the advisory opinion that the court will have ultimately deliver, and it just helps everybody in the development of human rights discourse. So there are two ways in which you can participate via the amicus brief to an advisory opinion case that's already before the court. The first one, and the court has consistently used this in all the advisory opinions that have come before it, the court itself sends an invitation to specific parties that it feels within its own, using its own discretion, can add value to the case. And as a standard procedure, they always invite all states on the continent. Once they publish it, you can look at related 3.2 of the protocol of the court rules that I spoke about. They always invite all states to submit, or the 55 or 54, I don't know when we are counting these African states, they invite all of them. And I think it's a great thing, because as we all know, states are the ultimate duty bearers of human rights. So you really want them to participate in any process that might shape or that might define what human rights look like. So the court does a good job of sending an invitation to all of them. It also sends an invitation to the Commission, the African Commission on Human and People's Rights, which, as most of you know, is the quasi, it's not a full court, it's a quasi tribunal of human rights. So they also invite them to make observations, and any other relevant AU organs, they send an invitation to them. And they also then extend an invitation to other entities that they think can add value to the case. And I'll show you in two case studies right at the end how they've done that. So for example, they can send to an academic institution that has got an interest or that has got demonstrable publications on a particular topic, let's say climate justice, or even to an individual, an eminent jurist in a particular area. The court can do that using its own powers, inherent powers to do that. So for those ones, it's easy. Once you are invited, it means you are in. And it's unfortunate that I was talking to a colleague the other day and was saying most of the states have actually not submitted any, because they sent an invitation in the climate justice case that Dina was talking about that we are working on way back in September, and they gave a deadline of December, 4th of December. And I think at the time, not even 4 states out of the 55 had made submissions. So as a result, they've extended that, and I'll talk about that a bit later. But what I wanted to say is a lot of organizations that we are working with that want to have a piece of the pie, you have to apply to be admitted. It's not automatic, and that's what I'll talk about secondly. So the first step is where the court invites you directly, and in terms of Rule 83 sub-Rule 2, the court, as a standard procedure, gives 90 days. But it can vary, it can make it longer. It's up to the court using its own inherent powers, as they have done in this particular case, the climate justice case. So that's the first side. The second side, so here I just highlight, I'll quickly go through this in case of time, some of them, the members of the AU bodies, the different bodies. And I think most of you that do advocacy work are familiar with these: your African Union Commission, your ECOSOC, your African Committee on Experts on the Rights and Welfare of the Child, who incidentally I just saw last week, they filed their submissions, which is great. To have an organ of the African Union filing its own submissions, especially when they are rights-based. So there are many, and you can see here, I was just giving as an example, the diversity of parties that can participate. You can see there you've got professors, you've got advocacy organizations, you've got specialized children network organizations, you've got even academic institutions, even international academic institutions, I need to emphasize that you can also participate, which is something that is great about the African system. It's open-ended in that. So there you go. So let's assume you were not part of those that were all invited directly. What do you do? Your opportunities comes via Rule 83, sub Rule 2, which says that any other interested party may actually submit a request to participate as an amicus. So it's a two-step process. I've already talked about the purpose of an amicus brief. You are adding perspectives to the subject matter jurisdiction. I think that's straightforward. But what is important to note is that it's a two-step process, and you can look at the. I've talked about the guidelines that I spoke about at the beginning, the fourth source of law. They will tell you to go and look at paragraph 25 and 28. The process is that you apply for leave. In other words, you apply to be admitted as amicus. When you're admitted as amicus, the court will then give you the number of days within which you file the substantive submissions, which is the arguments that you want to put before the court. So that is the process that they have. In previous processes, some organizations, they've combined the application and they've also put in their substantive submissions, and the court has tended to be liberal and accepted it. But I think it's just good to stick to the proceedings that the processes that are set out in the rules as well as in the praxis directions, and do that two-step process that I'm talking about. So if you look at Article 25 or Para 25 and 27 and 28 of the practice directions, those ones are the important ones. They tell you that you can make an application. They also tell you that the registrar will notify you whether you've been successful or not in terms of admission. And once you are admitted, of course, you then make your full submissions. I make the point there that there is no specific template. A lot of people I interact with, they ask about length, page count, words, and all that. Those things have not been specified by the court. But there are standard things that in some cases that I've worked on, and also some amicus briefs that I've seen that are filed by other organizations. I think there's a standard procedure that will make your application more palatable to the court. And quite obviously, I will not speak about the length because there's no guidance there. I think the shortest I've ever seen was like 4 pages, which was admitted. I've seen something that's more than 70 pages. Some people have got lots to say, but I think what is important is that your expertise must be stated, and you can attach a CV. It's important to state what is the contribution you want to put before the court. And of course, you file via the registry. In the next slide, you'll see the address. You put a synopsis of the arguments that you are going to make so that the court is aware in terms of what it is that you want to bring before the court. And it could be anything. If it could be a legal argument, it could be a comparative. I saw an excellent submissions by a colleague who, in this climate justice case, who was looking at how some of these questions that are before the court have been dealt with, like, for example, the Indo-American system, and bringing that before the African court. And I think it's great. It can be factual submissions. There are people that would want to, for example, if the question is on the climate justice impact, you can do affidavits about people that are directly affected. It could be, people that are near the ocean lines, people that are suffering from desertification. You can bring factual arguments on that. You can do those who are good in science or in economics. If that scientific argument and economic argument can speak ultimately to the human rights questions that are before the court, you are at liberty to do that. It's your duty to demonstrate to the court that you are a specialist or an expert in that particular area and what angle you want to bring before the court. So here I've just put really specific. So in a specific first page of an application to the court, and it relates to this climate justice case that we are working on. You can see there it was the first case in 2025, so advisory opinion 1 of 2025. So it's good to state the case, the parties that have brought it, because there are many cases that the court is dealing with. So you need to make sure that the court places your request for an amicus in the correct folder or the correct case that you want to be joined to. So this is just a structure that I would encourage anyone who is doing this to adopt with any preferred amendments. But I think quite clearly it's good to have a cover page, contents, if you are, especially for lawyers, table of authorities, then the identity and interest of the amicus curiae, why you want to be part to the process, introduction and summary of the arguments that you are going to make a statement of the issues that you are going to put before the court, your argument, your conclusion, and of course you sign off your documents and put your conduct details. I think it's standard and straightforward. Then I spoke about the communication methods. The court can receive documentation via registered post and via email. I think we encourage emails just because of the modern world that we are in, and you are also able to follow up on your case or your request before the court. Sometimes they're overwhelmed. We understand that with this climate justice case, they've received so many requests, more than any other case that they've had before. They're quite overwhelmed, and I think it's a good thing. So you can write to the registrar and submit your application and also do follow-ups. That there are also contact numbers on the website in case you feel that you've not received a response within reasonable time. There's nothing that stops you from reaching out to the African court. As we know, the African court is based in Arusha. You can follow up on that. Time limits, a strict application like any other legal process and any court of law. If you are given a time limit, file your papers within that time limit. And if you seek or you want to seek an extension for one reason or the other, you always have to ask the court, and the court grants permission depending on the arguments that you make. So, for example, those 90 days that I spoke about that you find in Rule 82.3, you count those days consecutively. It's important so that your reckoning of deaths is within the time dates, the time that has been prescribed by the court. So I thought it's just a nut and bolt, important to note. So the court has been busy with, for those that have an interest with numbers and statistics, with the contentious jurisdiction since it started its work. 366 cases, and this was correct as at the end of December. Then it's got 18 cases. It's disposed of 16 advisory opinion cases of those 18, and almost 90% of those were dismissed because of procedural issues. So it's very important to follow procedure. And they've got 2 that are pending, so they've been quite efficient in advisory opinion proceedings. And of those 2, they've been filed by PALU, as I said earlier on. The one that we have an interest in is the climate justice case. And there's another one, the death penalty case, that's also pending. And I think it's still open in terms of amicus, but I'm more engaged with this climate justice case. And that is the one that I'm saying it is still open in terms of filing amicus briefs. So on this page, the death penalty, my apologies, someone has just started a lawnmower. I hope you can hear me outside. Yes. So there are 2 cases, the death penalty case and the climate change case. And those 2 cases, if you have an interest in them, I think there's an opportunity to participate. Like I told you, most of the cases have been dismissed without full judgments. And if you want to just see how the court deals with advisory opinion, these 2 are great cases because they've got very comprehensive opinions that have been handed out, and they are being used with those who are in international law, international human rights. There was the vagrants case that was dealt with. It was an advisory opinion in 2018. There was also a COVID case. It was brought during the COVID time. We've forgotten about COVID, right? was quite a good case. So you can go to that website for this. The judgments are out, and you can see how these cases they've been dealt with, and it can just assist you in the work that you want to do with the African court. And they are quite they are available on the African court website, which works great. It will be easy to navigate to them. I was just here, I was just giving an example of some of the parties that were invited to the vagrants case. The ICJ Kenya, the Center for Human Rights of Pretoria, the Dula Oma Institute on Constitutional Rights, University of Western Cape, the Open Society Initiative, they participated in that case. So it just shows you that the court is quite willing to hear from different parties before determining cases that are before them. Same thing with the election case. Your usual suspects, your member states, your AU Commission, and then of course there were a few amicus curiae. I think I only saw 3 that were invited in that case. So it's quite interesting. And then the other thing I just wanted to note is that some people also ask in terms of how much time does the court takes. Nobody really knows because it's in the hands of the court. But the COVID case might give you an indication. So as an example, the first notification to parties, the publication was in August 2020. Then they did the usual, send out the requested observations. In January 21, they, as usual, gave the member states an extension. The member states never submit in time, but you don't operate like states. They will not give you that allowance. So stick to the times that you've been given. Then in January 21, they added some organizations to their list. So they might have questions, maybe that they feel they need more expert opinion, and they use those powers that I spoke about. Look at Rule 90, the inherent powers of court to do what is in the interest of justice. So they did that in that case. Then they admitted more partners in April 2021. And then, of course, in June 21, proceedings were closed. So once proceedings are closed, you cannot request to be joined, neither can you participate. So sometimes the court will determine the matters on the case, on the papers before it. This court, as far as I could research, has not done oral hearings, but we think with this climate justice, because of the very nuanced issues that are coming up, it might be a possibility. So in that case, July 2021, they handed down their opinion. So just over about a year, that case was dealt with. Our case, the climate justice case, we filed it in May. In fact, on the 2nd of May, 2025, which is last year. So if you want to look at your calendar, we are now just gone about 8 months. We are in January, and we know that there's an extension that's March 2026 for those that they've been admitted. So quite obviously, there will not be a judgment before 30 March 2026. Will they close submissions or they'll give another extension? We don't know. But as far as that case is concerned, the climate justice case, this is where we are. And I'm quite aware, I'm sure we can hear from some of you that are on the call. Some colleagues have been getting letters of admission, and they are busy working on their substantive arguments. So for now, 30 March is the key date that applies to all organizations that have been invited to submit or that have been given, whose application has been admitted. They can file before 30th of March 2026. So this is where we are. And Dina, let me stop here. Thank you so much. And thanks for listening.
Thank you, Dee. As ever, just so comprehensive and clear and incredibly useful, I think. We've had a few questions in the chat, but I think what we're going to do now is just open up. We've got another sort of 10 minutes in our scheduled time, so we're just going to open up for some questions. Feel free to put them in the chat or to raise your hand and ask them here. One thing that I can see that is coming up is a question about how to submit observer briefs. I hope it's now clear to everyone after Zi's talk that observer briefs are invited briefs, and that was a list that the court sent out that Z shared in a slide. So for all the rest of us who weren't specifically invited, we will be submitting amicus briefs, and we need the leave of the court to do so, as Z said, and so you have to submit a request. And then the other question I'm seeing again, which Z spoke to as well, was the question about, I've submitted a request to be admitted and I haven't heard from the court. The court doesn't have prescriptive timelines on how quickly they have to get back to you, as Z says. And so it's a little bit uncertain. As Z said, there is no harm in following up with them and writing to the registrar again. But it's probably worth noting that we have some information from our colleagues at the court that they are surprised by the unprecedented interest in this request, and so this is also new territory for the court. They're coping with I think an unprecedented level of emails, which is not a reason not to write to them. It is a reason to follow up. But as we say, there aren't strict timelines, so it's hard for us to tell you when you will hear from the court. Okay, so those are the questions that I saw coming up specifically in the chat. As I say, please raise a hand if you want to ask us something, or feel free to ask us. I see a question, can we get the presentation later? Yes, it's already in our Google folder. I've shared a link to the Google folder in the chat. I can share it again. So have a look there. We have also put a copy of our sort of template for requesting to be admitted, as well as our hopes and ambitions document, a few other documents that you might find useful. Any other questions at this point?
Yeah, sorry, Dina, I just saw someone saying, how do we join in as observers? I'm not too sure whether they are referring to being an amicus or observer to what, if they want to clarify so that we can answer. I think it's Eunice.
So Eunice, I think, asked a couple of times and further up said they hadn't been invited as an observer.
Okay, so they want, if they applied.
No, I think that's what they were.
So that's the first step. They need to file a request. Like I said, if you have not been automatically invited, you need to apply. And if you have applied, then you can do the follow-ups. And we're quite happy. I mean, our contact details are there to just assist in terms of the process. But the important thing is you must apply. In other words, you must submit your application to the African Court.
Yeah, and as Z says, please do ask us if you need support. It's worth saying you don't need a lawyer you don't need legal representation to submit a request to be admitted as an amicus. So anyone can do this, but we also recognize that the legal framework is not totally obvious, and so you might just want some legal advice from us. So do just write to me or Z or other members of our team, and we will try and get back to you quickly. There's a question about the process. Do we anticipate that those who did not yet get a response to a request will at least receive a new deadline similar to the first batch? Do you want to answer that, Z?
So what's the question? Sorry.
I think they're asking about what they should anticipate. If their request to be admitted as an amicus gets accepted, what should they expect in terms of a timeline for submitting their brief?
Okay. So that one, nobody knows except the court itself. The court will give guidance. So the standard period they give is 90. But like I said, if you look at Rule 90 of the rules, it says the court retains inherent jurisdiction to do what's in the interest of justice. So the court always, the good thing is they always tell you submit within this kind of period. So don't worry too much about that. Just make your application and the court will advise in terms of period. But like I said, you don't wait for the court to give you date. You start working on your substantive arguments. That's why in my presentation, I was saying these are the things that you have to go into the substantive so that you don't waste time, because it can really take you time to finalize your submission. So once you do your application, please proceed as if you know that the court is going to admit you, and be ready when you are called.
Yeah, maybe just to just agree with and emphasize what Z is saying, formally speaking, you could submit a request to be admitted at any point, and in theory, you should get around 90 days, but the court has discretion in this regard. And we know that at some point, the court is going to close the gates on this and proceed. And so this is why we are encouraging you, even though that end of March doesn't apply to you if you haven't yet been admitted as an amicus, that doesn't mean that the court won't use its discretion and impose that as a deadline if it wants to get on with things. So our advice is to, as Z says, kind of to submit your request, and even though you haven't heard anything yet, begin to prepare your brief, and connected to that end of March deadline, we know of a couple of states who are intending to request yet another extension. So while we don't know for sure yet, we think that the court will hopefully extend again, because obviously accommodating states is critically important to the court. But nevertheless, at this point, the date we have is end of March, and so we encourage you to just attend to it. Other questions? A request for a copy of the presentation. It is in our Google Drive. You can see it right now. So please go ahead and have a look there. We will make the recording available to everyone who registered for this webinar. We'll send a link to it. We're also going to try and host it on the African Climate Platform's website. That might take us a little bit more time, but we'll make the recording available to all the registries as soon as I can. Reshare the link to the drive, sure thing. Any other questions or any other points you want to raise, Z?
No, I think it's great. Is that a end, Sophia? I see a hand that she's
You're
muted.
muted.
Yes.
I'm muted. Okay, yes, I managed it. Hi, everyone. Thank you very much for this great opportunity. Yes, just a random question popped up in my mind, as I admit I'm not so familiar with international climate law, but I regularly read about the adverse impact of climate change on gender equality. Is this specific matter addressed in this particular request for advisory opinion, as I at this stage of developing my knowledge, I don't know if or to what extent it is highlighted in the advisory opinion of the Inter-American Court of Human Rights, for instance, because I more generally only noticed the matter of the intergenerational equity as such in this specific document, as well as if I well know in the advisory opinion of the International Court of Justice. So thank you for any enlightening insights in this topic in advance.
Yeah, sure. So definitely the question of gender equality is dealt with in the request. And I also know, I'm not sure if today we've got a number of organizations that are working on that angle. But when we had one of these meetings where we were meeting others, we had quite a number of organizations that proposed. I'm sure if you look at that, Dina, the list that you sent, it's there on the Google Docs. You can, it has got the theme, it's got organizations that are filing or have filed amicus, and then the themes. You see there are a number that are dealing with that question. So as you can imagine, Sophia, yes, the impact change has got that compound effect on particular groups. And we highlighted that in our application. You know, we highlighted the human rights defenders, the gender angle, there's the migration angle, there's the children's angle. But what is most helpful is those organizations that work in those areas to make the more substantive arguments. It always helps. So if you are one of those people that is an expert in that, I would really encourage you to do that, because there are organizations that specifically work on nuances and they are better placed to speak about these things in relation to the climate change. Yeah, put it before the court, please.
Thank you very much. I'm actually attending this webinar in my personal capacity as a legal professional seeking currently further opportunities to advance my knowledge of international law, but I'm really grateful for all the information, and I hope I can contribute to your endeavors as well.
Thank you. Sure.
Thank you so much.
Let's keep connecting. Absolutely.
Thank you, and have a nice
Thank
day.
you, everybody. I'm conscious that we are now kind of at the end of our allocated time. I just wanted to say that we have two more planned webinars coming up, both of which are particularly focused on climate science and integrating and referring to climate science in your amicus briefs. So please keep an eye out for those if you'd be interested in that. And we have previously, in addition to these capacity building workshops, we have hosted, writing workshops and other activities to support people submitting an amicus brief. So if you feel like there is something you would particularly want to see the working group provide you, or some particular kind of support you want. We also just had an open Q&A last year, which I think was really valuable. So if, as you're drafting, you feel like a chance to sort of get together in this or a slightly different capacity to ask questions and to talk to the lawyers, then please just drop me or Z an email. We really just want to support your efforts and endeavors in all the ways that we can. So just a really big thank you to Z. Z has, in addition to the slides, written a really helpful overview of the whole process and the law and submitting an amicus brief and the distinction between observers and an amicus. And that document, it's a PDF text, is also available in the Google Drive. So if you want to revisit some of the things that Z talked about in more detail, that is a great place to start. So again, big thank you to Z, and a big thank you to all of you for being here and for engaging in this really critically important piece of litigation. And we look forward to hearing from you.
Thank you.
Thanks, everybody.
Thank you.
Okay, thank you.
Thanks, bye.